Member Warmington, are you saying that the record in the minutes of the decision of the committee is incorrect, or is it that you did not recall?
If I did not recall, Madam Acting Chairman, I would not have said what I said. If it's a matter of not recalling, I would not have said what I said definitively. A decision was not taken. That's what I said, and I stand by that. Senator Golin was the only one who spoke on that, and she said she would not support. So a decision cannot be taken based on the position of one member.
All right, so you're asking for this to be corrected?
It has to be.
All right.
It is not reflecting what the position was.
Yes?
Good morning, Chair, members, colleagues. So I have a note, but my note is just my note. So I would perhaps suggest you check Hansard, because I do have a note that it wasn't accepted.
Your note says that the recommendation was not accepted.
Right, because you will recall that from time to time, I will make interventions to ask about the decisions of the committee. So I usually ask the chair, who usually responds to me. So I have a note, but I'm suggesting we check Hansard.
Very well. Are we able to do so now?
I don't think we can do that now.
All right. If we're not able to do so, then we would not be able to confirm the minutes. So I would ask that the record show that all pages except page 8, the decision of the committee in respect of section 55, subsection 5, have been confirmed. So all except this. And we would seek the assistance of, all right. So I'll just put, we can just stand these minutes down and we go to the next minutes.
Yeah.
Those are printed? No.
We were circulated at the last meeting.
I'm advised that the minutes of the meeting held on January 28 were circulated at the last meeting. Right. I am advised that the printing services are temporarily down. All right. You want to check if the service? All right. The committee clerk will just check if he's able to get some copies printed. The minutes nonetheless were circulated electronically, so if members have access to the electronic copy while we await printed copies, I would invite you to check. Please go and check.
I'm going to make sure everything is sent.
Mr. Nixon et al. He's just coming. We're awaiting the return of the committee clerk, who's checking for printed copies. Do members have access to the electronic copy of the minutes of the meeting of January 28th? Okay. All right.
Someone else been? Dr. Guy? Dr. Guy?
Yes. So, no, I had a copy, you know.
Oh, you have a copy?
This is it?
Yeah, that's
Yes.
it. That's
Yeah.
it. I can give it to you.
All right. All right, we go to the minutes of meeting held on January 28, 2025. Page 1, attendance. Call to order. If there is no correction to page 1, we can confirm and go to page 2. If there is no correction to page 2, we can go to page 3. All right, page? Yes? Yes. Apologies for absence were tendered on behalf of members Julian Robinson and Senators Peter Bunting and Donna Scott Motley. So members should be pluralized. Anything else? If you go to page 1, absent members, you would see the 3 members listed as apology.
It's not this one. This one I'm talking about.
Yes. All right.
Okay.
Page 3. Page 3, the penultimate paragraph, sentence commencing, Member Malahoo Fort also noted that the rationale given by Bess FM was that the reason for not filing could be the very root of corruption that one was seeking to unearth and dislodge. She suggested that this concern be further reviewed by the committee in relation to disqualification. I'm not sure if that captured it accurately. My recollection is that I noted and agreed with the rationale given by Bess FM and asked that it be further considered by the committee. So I would ask that the sentences be amended to read, Member Malahoo Fort also noted and agreed with the rationale given by Best FM that the reason for not filing could be the very root of the corruption one was seeking to unearth and dislodge. She suggested that the matter be further considered by the committee. Full stop. If there is no other correction to page 3, we can go to page 4. There is no correction to page 4. We can go to page 5. If there is no correction to page 5, we go to page 6. I note that the penultimate paragraph on page 6 is the same as the penultimate paragraph on page 7. Those two paragraphs have been duplicated. Member Malahoo Ford suggested that the Act might need some level of restructuring, and not some level of restructuring, but simply some restructuring, or that the Act might need to be restructured. Member Guy. Yes. So if it is that the point was repeated, it could simply be stated that reiterated the need for some restructuring of the Act. Yes. Yes. That may be editing. All right? Yes. So we can delete the penultimate and ultimate paragraphs on page 7 without doing any harm to the minutes. That is my proposal. All right, we go to page 8. The same thing. Mrs. Celia Brown, you're saying? Yes. Right. Did you get a chance to read them over?
Oh, these one, no, but I didn't get to do them.
Okay.
The question, tell me what the-
I'm sorry?
That one has it, and this one has it then.
May I ask members to check whether the printed minutes you have, whether they're paginated?
No?
No?
Oh, okay. Okay. Interesting. That's okay. If the content is the same, then that's...
All right, we go to page 9. If there is no correction to page 9, we go to page 10. If there is no correction to page 10, we go to page 11. No correction. We go to page 12. There is no correction to page 12. We go to page 13 and 14. All right, so we can move for confirmation as corrected on pages 2, 3, 6, and 7. Will someone move for the confirmation? All right. On a motion by Member Guy. Yeah. Seconded by Member Robinson. Yes. All right, we can go back to the page of the minutes. All right, Member Warmington, we have the benefit of the record in the Hansard, page 44, I see, and section 55, I think that's the only, no, I'm sorry. Member Warmington also proposed to delete section 55, subsection 5, which reads as follows: for the purposes of the Defamation Act, any report made by the Commission under this Act and any fair and accurate comment thereon shall be deemed to be privileged. And his rationale is that the immunity given to members of the Commission and staff must be amended so as to remove this immunity. I don't believe the Permanent Secretary's Board had a comment on privilege. That's Senator Golding Campbell speaking. Chairman, right. Senator Campbell, and just to clarify, and for those listening, Chair, Section 55 begins Part 7 of the Act, Privilege and Confidentiality. And it says at subsection 1, subject to subsection 2, no proceedings shall be brought against any person in respect of any action carried out by the person in the performance of his functions under this Act. However, the privilege is limited in that it does not apply to proceedings on the ground of gross negligence, malice, or the use of unreasonable force. Subsection 3 speaks to, quote, no proceedings whatsoever shall lie against the Commission, except as specified under subsection 2, that's the part about gross negligence and malice. No proceedings whatsoever shall lie against the Commissioner or any person authorized by the Commission for anything done, reported, or said by the Commission in the performance of its functions under this Act. And at subsection 4, anything said or information supplied or any document or thing produced by any person for the purpose or in the course of an investigation, etc. Let's see. Member Warmington saying that wouldn't serve. Chairman says so we move on to the next position. Senator Campbell Golding, the next position, Chair, is that the immunity from suit for defamation be removed from the Commission. That's at subsection 5. I'm afraid, Chair, that I also don't think I could agree with this one. I think if we put our bodies under threat of suit for defamation, that is definitely one way of completely gagging them. Mr. Warmington said they wouldn't serve. Senator Campbell, yes, and so, but the other thing is we are making such sweeping amendments to this Act that I think we're putting in some of the safeguards to ensure that there is no reckless commentary and so on that's happening here. And as I say that, Chair, yes, SG had acknowledged that she would review her files. Chairman, Section 56, Senator Campbell. 56 is confidentiality regarding information, and the Integrity Commission has recommended that having reviewed, right, that's the extent of it. So there is no record that the decision was taken. Yeah. Just a minute. Member Warmington, I assume you're therefore proposing that the decision of the committee be amended to reflect that the committee did not make a decision on whether to delete section 55.5. Okay. All right. The committee did not make any decision on the recommendation to delete section 55.5. So we can move for confirmation of the minutes as corrected on pages 2 and 8. Member Warmington, are you moving the motion to confirm the minutes as corrected? Seconded by? Member Hamilton? All right. Any matter arising from the minutes as corrected and confirmed?
So I believe SG would have captured them in her.
All right, members, in respect of the matters that appear to arise from the minutes of the meeting held on February 4, I think those are captured in the memorandum provided by the Solicitor General from the Attorney General's chambers. This document. Printed copies were disseminated, I understand. For good order, perhaps the Solicitor General can take us through the memorandum as the primary matter arising. So we're looking at the document headed Confidentiality, Non-Disclosure Provisions in Similar Integrity in Public Life Legislation, prepared by the Attorney General's Chambers, February 2025. Right, we see the countries cited: Turks and Caicos, New Zealand, Canada, Australia, Trinidad and Tobago. Madam SG.
Okay, thank you. First, although it says prepared by the Attorney General's Chambers, which is true, I have to give credit to Monique Adams, who is not here today. She's unavoidably absent. And I'm giving credit to her because we were going through the matrices, minutes, and we realized that the committee asked a whole lot of things of the Attorney General's Chambers. So in fact, there are a number of other matters that time permitting, I will be able to discuss today. But the reason this matrix was compiled was due to questions that had come, I think, from Senator Scott Motley and some others about the comparisons of what's in our Integrity Commission, the confidentiality provision there, and what's elsewhere. Because the Integrity Commission has made a request. I think they have made a request, but there are a number of other persons who have issues with the confidentiality provision, which they call, parts of it they call a gag clause. And so it's for this reason we just did a comparison. Maybe to just give the committee members an idea of what exists elsewhere.
Just a minute, SG. Member Robinson?
I think there are two separate issues. I think the issues in this document relate primarily to the concerns that were raised about the inability of the the interpretation of the Act by the Integrity Commission, which they have said precludes them from publishing contracts and other awards by the government. The confidentiality clause, which I think is separate from what is commonly known as the gag clause, which is Section 53. But the concerns that I certainly raised were, and I think that was Section 56, the interpretation of what confidentiality meant, and the Commission interpreted that to mean any information provided to them, which would include information like contracts, which certainly would not have been the intent of the legislation.
Very well. Noted. SG?
Oh, I really didn't have much else to say other than this was just to give the committee members an idea of what exists elsewhere to see if you thought that the provisions in this act needed to be buttressed or remain the same?
Well, since we have to, the committee has to make a decision on the matter, it may be helpful to just look comparatively as what is elsewhere. Member Warmington?
If I recall, the Permanent Secretary Board had made a recommendation where this was concerned. And then we have the issue with Turks and Caicos Island and the ruling by the Privy Council, whereby they ruled then that is an invasion of privacy for the Commission to be seeking information that can be had from the declarant. And what the Permanent Secretary Board asks for is that they seek such information from the declarant. And if there's a case where the declarant refuses or does not supply the full thing, then they can seek an order from the court to go get that information instead of just going directly to a bank or anywhere else for that such information. They ought to seek an order from the court. And that was what the Privy Council ruled in the case in the Turks and Caicos Island. And that's what the issue was. But we hadn't taken a final decision. The Solicitor General gave her opinion, and we hadn't taken a decision. But I think that was what it was, really.
Guidance as to whether or not the provisions in the Turks and Caicos legislation was the same as in our legislation in light of the recommendation from the Permanent Secretary's Board. Because I thought it was important to know whether we could just simply say that this was how we wanted to amend the legislation.
Thank you, Member Scott Motley. We're looking at our section 56, the confidentiality regarding information. Our section 56 has 3 subsections, and it is subject to section 42, subsection 3B, which deals with examination of statutory declarations and publication of summary declarations in certain cases. The memo from the chambers advises that section 47, subsections 1 and 2 of the Turks and Caicos Integrity Commission Ordinance provide 47.1, every member of the commission and every person performing any function in the service or as an employee of the commission shall treat all records and information relating to declarations as secret and confidential, and shall not disclose or communicate the text of any record or information or declaration to any unauthorized person, or to allow any unauthorized person to have access to any records, information, or declarations. Subsection 2, a person who contravenes subsection 1 commits an offense and is liable on summary conviction to a fine of $20,000 or to both, or to a term of imprisonment of 3 years, or to both. So it's the same duty to treat as secret and confidential all information. Yes. Yeah. Well, no, same in respect of the duty to treat as secret and confidential, not worded in the same way. Yes.
Yes, I think that is distinct from the point that Senator Scott Motley made as it relates to the Privy Council decision and how the Integrity Commission should operate. What we're reading now is basically how the Integrity Commission treats with information. My question is, what particular section of our legislation should we look at to determine whether it is in sync with the ruling of the Privy Council?
Right.
And it's not any of these that we've just read.
So it's actually several issues, and it's different provisions that deal with all of these issues. So this confidentiality more relates to Section 56, and it's more a comparator with Section 56. But the issue, as Member Robinson said, was that in our Section 56, we talk about dealing with as secret and confidential, not just statutory declarations, but government contracts, prescribed licenses, and all other matters. And so when you look at now the comparison with like Turks and Caicos, they confine it to the declaration and matters relating to the declaration. Also, you'll note that they don't have the ongoing obligation for secrecy. So our confidentiality provision, I think, is at a higher standard, which to me, in my view, is consistent with our constitutional right to privacy, which we have. I'm sure most persons understand that the right we have is not really replicated in many other. In fact, I think we can find it maybe in one other constitution, but generally it's a right that we took from human rights declarations. So our confidentiality provision is a little stronger than most others, but then it also goes wider. It goes beyond the declarations. It speaks about government contracts and prescribed licenses. So in Turks and Caicos, you'll see that it is limited to the declarations.
I think the concern, so the provision at 56, is it bringing over matters from the Contractor General provision and merging it? And the question would arise is whether the public interest is served in concealing information in respect of government contracts, because the contracts are paid for out of public funds. Just let's try to get an understanding of what it is that we're seeking to address. The question is whether it is in the public interest to conceal information in respect of government contracts, having regard to how government contracts are intended to operate. All right. The other question is whether a distinction ought to be made between statutory declarations, which are submitted by the declarant and which may have certain private and confidential information, as opposed to the government contracts, and also licensees. I think that is what the committee would need to focus its mind on.
Madam Chair, there's a very clear distinction between statutory declarations, where people provide very personal details about their assets and their income. There's also a distinction between, in the course of an investigation, where you're going to get information sensitive to the outcome of an investigation. It is clear in my mind that those things must be subject to provisions that protect, in the strictest way, the privacy and confidentiality. As it relates to government contracts, which go through a very detailed process of public procurement, you have a public procurement authority body, matters go to cabinet. Those contracts, we get them here in Parliament from the cabinet notes. There's no reason for those types of government contracts to be subject to confidentiality provisions. It is clearly in the public interest for the public to know how its money is being spent and where contracts are being awarded. So the amendments must take note of the distinction between contracts and licenses versus declarations or information that's important in the execution of an investigation.
You mentioned was limited to what have you? I'm saying it isn't limited to that. Where the declaration is concerned, that's one I raise, whereby this Permanent Secretary Board asks that it be amended, whereby the the Integrity Commission, if you need additional information, you seek it from the declarant. And in a case where there's a refusal or they're not cooperating, then they seek an order from the court. Instead of going to bank on all of the areas behind the declarant, what they're asking for is that they seek such information from the declarant, and when there's no cooperation, then they get an order from the court, instead of just going directly to the bank or to any place else out there to get this information.
Member
Prove to the
Warmington.
court that they need that information and the grounds on which they need it.
That appears to be a separate issue.
Yeah.
A separate issue. So let's just. I'm sorry. All right. So
Right.
let's, for good order, let's deal with the issues separately. All right. So the question we are now addressing is whether the public's interest is served by keeping secret and confidential matters relating to government contracts and licenses issued by the government. And it may be helpful to look at licensing as part of a regulatory regime, that is intended to do, and to look at government contracts in the context in which contracts are awarded.
So,
Member,
right, you're speaking specifically to, my mic, is my mic on? You're speaking specifically to section 56.
just a minute.
No.
Can you turn your mic off? Yes.
Sorry, Madam Chairman, you're speaking, you want us to focus on section 56 at this point, is what I'm gathering
Yes.
from your comments.
Yes.
And I would remind the committee that prior to the passage of this Integrity Commission Act, the Contractor General published on a monthly basis, I believe it was, either monthly or quarterly, all government contracts that went through the National Contracts Commission, etc. In fact, I believe the only licenses as well, I believe it was only land sales or leases that were excluded from what the Contractor General published. And there was even some question as to why that was excluded and that it should have been included. And I believe even after the Integrity Commission Act came into effect, for some time they were still publishing it. And then after, interpreting this particular section, they ceased. But it makes absolutely no sense, because the whole, the process of advertising, tendering, procuring, signing these, approving at cabinet, coming to being interrogated at the Standing Finance Committee of Parliament, etc. These are all already public documents. So it makes no sense for those to be included in this section. I can see the private statutory declarations and perhaps private contracts that may not involve government being included here, but certainly anything to do with government contracts, licenses, leases, etc. I don't see how that can be considered confidential, and it shouldn't be. In fact, it should be. I think they should return to their original practice of publishing these on a regular basis.
Member Charles, you. And then we'll come.
Thank you, Chair. Perhaps SG will be able to give an opinion on this, but I was just wondering whether the section is speaking to limiting public access to the information, or whether it is really just a matter of the design being one to give some parameters to how persons in that institution would treat with all matters, including government contracts. My reading of it is that it's simply, that it's not trying to stifle transparency, but rather it is trying to create some kind of guideline to effectively define how the persons who are operating, and we don't know the extent of the range of what work they'll be doing with these matters, but to ensure that in that operation, while you're in the Integrity Commission, that you treat the things in an appropriate way, and so making them to those parties sensitive and confidential, I think, protects the integrity of their own internal procedures and operation. As was said by another member, some of the documents may very well be public, or may be able to be accessed by the public by various means. So perhaps we have to look on the drafting, but I don't think that it is a matter of trying to stifle transparency in itself. But again, SG.
Madam Chair, thank you very much. And can I just make a belated apologies for my tardiness today? I have more questions than I really do have a comment, because as what Member Bunting was referring to, the publication of government contracts and licenses, when it did occur, and the members who would have been participating in the arena at that time can indicate, at what point did the Commission in those days list those contracts and so on? At what point in the process? That's my, At the end, once this contract was awarded, right? So I do have some empathy for the Commission in terms of how they have interpreted this provision, because we do use the sweeping language of all information, and that all qualifies everything coming after it. So I think this is one of those that if we're seeking to ensure transparency, then contracts, these kinds of public interest matters probably ought to be disclosed, and we should amend this provision to direct that. I would just say, though, I'll end there. I think I'm in support of it. I of course would expect that it would not necessarily be all government contracts, and I would imagine the ones that have to do with national security, those issues would have the usual protections from that kind of public disclosure. That was the last. Thank you.
Let's be clear what we are addressing. The concerns have been raised by 3 entities in respect of 56. Firstly, by the Integrity Commission, and it is saying that it's really asking for the section to be amended to achieve a proportionate balance between matters which are deemed secret and confidential and should rightfully be treated as such, and the broader objective of openness and transparency, which are crucial to anti-corruption efforts and are deemed to be international best practices. So that is one ask. Jamaican for Justice has gone a little further and is saying that all statutory declarations should be published. Remember, the section is subject to 46. Well, it says it is recommended, yes, for all parliamentarians. Yes. Just, right? And then the Jamaica Accountability Meter portal, they're asking the committee to consider if section 56 serves to stem or support the fight against corruption. They're asking that we weigh if the section supports or denies the Commission of its contractual responsibility to educate the public, and they're of the view that the restrictions on disclosure are deleterious to good government, and they are and inconsistent with one of the fundamental principles underlying the system of constitutional democracy outlined in Section 2 of the Access to Information Act. Those principles are accountability, transparency, public participation, all of which are significantly impacted by 53(3) and 56(1). And they are recommending rewording of the section to repair the concerns. Their rationale is that 56(1) is another injurious gag clause that obstructs the Jamaican taxpayer from having access to basic information about how their funds are utilized to contract the services of private sector parties. It also obstructs the very legislators who preside over matters of maladministration in procurement at the Public Accounts Committee and the Public Administration and Appropriations Committee, including says Jamaica Accountability Meter Portal. Section 56 subsection 1 is another injurious gag clause that obstructs the Jamaican taxpayer from having access to basic information about how their funds are utilized to contract the services of private sector parties. It also obstructs the very legislators who preside over matters of maladministration in procurement at the Public Accounts Committee and the Public Administration and Appropriations Committee, including those who oversee the actual work of the Integrity Commission. Please come on the mic.
So where is she reading from?
Yeah, I think there's some confusion there because Section 56(1) would not apply to legislators, say on the Public Accounts Committee, etc. So it's not relevant to that section. Yes, I think we're all agreed that the publication of government contracts and so on, subject to whatever restrictions for national security and foreign affairs or whatever the standard limitations are. But I don't think there's any disagreement that we could return to the regime that existed under the old Contractor General's Act, which would bat all public contracts, once they were awarded, not during necessarily the tender or the negotiation process, but once they were awarded, that they should be published promptly. And I believe it was either monthly or quarterly. It slips me now, but it was very regularly, I think quarterly. And I would only say that there was a limitation then for some reason, and I don't know the history, but they did not include land sales by entities like UDC or so on, which I think it should include all of those. So the general contracts for procurement, for construction, licensing, etc., I think we're all agreed that those should be published in the interest of transparency in the public interest and so on. So I don't think there's I don't sense any disagreement in the committee on that. And I don't think it actually operates 56(1) to restrict legislators using other pieces of legislation, whether at the Public Accounts Committee or they examining the Auditor General's reports, etc. So I think they've gone a bit, their interpretation has gone overboard. But I think we can all agree and move on from 56(1) that it needs, we could probably ask help to draft a replacement section for 56(1) that is not as restrictive, and then we could recommend that as in the report of the Joint Select Committee.
Thank you, Chair. I don't think there's any dissonance with the committee saying and what the Jamaica Accountability Meter Portal is asking. in and I'll just shorten the conversation by saying, as agreed with Senator Bunting, I have a different read to this, though, and what they might be suggesting, or are suggesting, is that the fact that those contracts are public, that when it comes before the PAC or the PAAC, that there is no hindrance to us interrogating those contracts. So basically, it is asking for more information to be available to the committees by the non-inclusion of public contracts in 56.1.
Again, just to say, and I just want to make my point clear on how I'm interpreting this, and it's not frivolous. So I want colleagues to hear me out. Section 56, as my understanding, as I'm hearing, is that there's a concern that it is restraining transparency and accountability of these government contracts. Now let me read it out. Subject to section 42(3)(b), every person having an official duty under this act or being employed or otherwise concerned in the administration of this act, hereinafter called a concerned person, meaning it's relating to only that category of persons, concerned persons, shall regard and deal with as secret and confidential, which means we're saying that the concerned persons must treat with these things as secret and confidential. Okay? So I don't view it to say that government contracts are now restrained. In my understanding, is that all information, statutory government, etc. But it's speaking to how they must operate when dealing with matters at the Integrity Commission or internally. That's my understanding. Again, I would love to hear what others think, but I don't think that this is going to stop the public from having the usual.
Just a minute. I'm smiling, because I remember the first time I made a presentation in the sectoral debate in my then role as Attorney General. I issued a caution to colleague legislators that when we come to ascertain the intention of Parliament, it's not the subjective intention of a single parliamentarian, but the intention is ascertained from the words used, because you are interpreting what is approved in a provision. And what is very clear is that different people have different interpretation of it. And it's taking the administration of the provision in many different directions. So for that single reason alone, the provision will require some clarity. For that single reason alone. I think, though, it may be helpful to try to understand what the submissions say. The Integrity Commission is saying that it does not strike the right balance. That's one. The Jamaican for Justice is saying that they would ask that all matters be, the statutory declarations of all parliamentarians be published. And I suspect the reason they're asking for that is because of the reference to 42(3)(b), which says that although there is a general duty of confidentiality and treating as secret and confidential all matters, you can publish the statutory declarations of the Prime Minister and the Leader of the Opposition. So I think 42(3)(b). So it's not as far-fetched as they're saying. If you seek to understand their submission in the context. And Jamaica Accountability Portal now has gone to, no, we're not saying whether we agree or disagree. We first have to understand the point. And then the other group has gone to an extreme example of saying if matters are treated so broadly as secret and confidential, then it will hinder parliamentarians in the work that is given to them in, say, for example, the 2 committees that are named. I believe those are the submissions. Just
I think you turned on mine by mistake when you meant
Chair.
to turn on.
I just wanted to just a quick note, just to clarify though, the submission from JFJ. Yes, it is true that a summary of the statutory declaration of the Prime Minister and Leader of the Opposition are disclosed. It's a summary, and it was tailored in a very specific way to ensure that it would not infringe their right to privacy. So a balance was struck as to how this summary was compiled. It's not the entire, it's not a full declaration that what everybody else. So again, in that call for parliamentarians to disclose, I would then say, if that was being considered, it would also have to take the same form as what is now done by the PM and the Leader of the Opposition, which is a summary, not the full declaration.
Just a minute, members. Just a minute. In the interest of time, I think let us just be clear. The consideration is to be given to whether we are going to take out the contracts and licenses, the government contracts and licenses from the provision, and so strike a better balance. So we're clarifying what information is to be treated as secret and confidential for good reason, and what information can be made public in light of how things have operated in the past, and even in light of the fact that when contracts are awarded, those are tabled in the Parliament. And there's a whole complex procedure around the award of government contract. Member Golding, and then I come to you, Member Guy. Or was it the other way around?
But to be honest with you, Chair, I can withdraw because I think you have given the clarity in terms of what are we focused on and what is the committee's position on the government contracts and licenses.
Very well.
I just want to say one further thing in relation to Member Charles's submission, because I've read the clause a little more, and he didn't continue on, but when it lists out the declarations, the contracts, prescribed license, and that is followed by, and all other matters relating to any matter before the commission. I am supporting the point that he made, but I do understand why the Integrity Commission would have felt the way it felt. I think the subject to Section 42(3)(b) at the beginning of the provision is what brought that confusion into play. But at the end of the day, what is our intent now? This is our opportunity to amend the Act to make it more workable, and I support the publication of licenses and contracts, government contracts.
Very well. Member Guy.
Thank you, Chair. It was instructive that Member Golding spoke before me, because essentially what I'm saying, whilst agreeing with her, it is the interpretation of the Integrity Commission of 56(1) that has caused this dilemma here. And therefore, it is up to the legislators to make sure that there is no misinterpretation in the review of this piece part of the legislation. Hence, the discussions that all of us have had so far in excluding the contracts and licenses ought to be properly done in the review, and we seek to get proper wording from the drafts persons in this respect.
May I just say that I have come to learn over time that what we need to be clear on is the policy, not so much the wording, right? Because we run ourselves into problem when we legislate by drafting before we are clear about the policy intent of a provision. So if the intention if having heard the concern, we are agreeing that it was not the intention to treat secretly and confidentially government contracts and licenses and prescribed licenses in the same way as information relating to statutory declarations and the statutory declarations themselves, and that the public interest would be served by not treating secretly and confidentially those two matters, that is, government contracts and prescribed licenses, then the section should be amended to reflect that. It's kind of a convoluted way of saying it, but
Yeah, I was just saying that I agree with your summary, and I think we could move on.
all right. We also want to avoid any misunderstanding about what is being recommended by the committee going forward. So we will put the recommendation after hearing Member Hamilton and then the Learned Solicitor General.
Chair, you made a valid point in relation to the policy. So while I agree with everybody else that the government contracts and prescribed licenses inclusion as it is now creates a problem, I would really love to know why it was placed there in the first place. You know, there must have been some consideration as to why it was included. So yes, we may need some amendments, but it would have to be subject to what the policy was initially.
Thank you, Member Hamilton. SG?
Okay, thank you. So the reason there is a reference, specific reference to government contracts and prescribed licenses comes from starting with section 51. So you actually have a heading, conduct of investigation in relation to government contracts and prescribed licenses. Then you have section 51 that the marginal note says Director of Investigation to be advised of matters relating to contracts, relating to government, but really it's about in relation to government contracts and prescribed licenses. And then you will go on to section 52. So it's a small part, 2 sections in the Act dedicated to the treatment of and the Integrity Commission getting information about government contracts and prescribed licenses. So I suspect because of that very specific treatment, those words would then have been included in the confidentiality provision. But what I want to bring to attention is section 56.3. So I know everybody has focused on 56.1, which makes sense. But when you go to 56.3, it says, every concerned person who is required under subsection 1 to deal with matters specified therein as secret and confidential, who at any time communicates or attempts to communicate any such information, declaration, letter, and other document or thing referred to in subsection 1, disclosed to him in the execution of any of the provisions of this Act to any person, A, other than a person to whom he is authorized under this Act to communicate it, or B, otherwise than for the purpose of this Act, commits an offense. So there, I would call these, let's call them exceptions. So you don't commit an offense if you communicate the information to someone who you're supposed to communicate it to as authorized under the Act, or if you do it for purpose of the Act. Now, I'll admit that that language, otherwise than for the purpose of this Act, is a little vague. I'll go then to section 56.3 of the Integrity Commission Act. So I'll go now to section 24 of the Contractor General Act, which was, the marginal note said secrecy of information. So it was a confidentiality provision. But it said in 24.1b So it said the Contractor General and every person concerned with the administration of this act shall regard as secret and confidential all documents, information, and things disclosed to them in the execution of any of the provisions of this act, except that no disclosure, I'll read the whole thing, A, made by a Contractor General or any person aforesaid in proceedings for an offense under Section 29 of this act or under the Perjury Act, or B, so this is again, except that no disclosure which a Contractor General thinks necessary to make in the discharge of his functions or for the purpose of executing any of the provisions of, and then it listed 3 sections, shall be deemed inconsistent with any duty imposed by this section. So I think that language was a little clearer to say if the Contractor General is discharging his functions under the Act or executing, and the sections that they highlighted were reports. So Section 28 was reports to Parliament. Section 20 was the report, a procedure after investigation, and then Section 21 was disciplinary actions being taken against officers. That if the information was disclosed in those circumstances, it would not commit an offense. This is very similar to what we see in some other legislation. So for instance, in New Zealand, in the Serious Fraud Office Act, to read it from here, Section 36, so it's on the sheet, section on page 2, sorry, the pages aren't numbered, but page 2, so section 36(2) talks about notwithstanding subsection 1, the director may disclose such information, and you have a list of things A to E. So for instance, for the purposes of this act or in connection with the exercise of powers under this act, to the extent that the information is available to the public under any act. So my suggestion is, you do need to have a robust confidentiality provision. However, you can make exceptions about what can be disclosed. And in fact, this act already attempts to do that. Perhaps it did not do it in a very clear manner. So what I am suggesting is that what the committee should be looking at is not necessarily to delete government contracts and prescribed licenses, because the words after that would cover them anyway, and all other matters relating to any matter before the commission. Anything that comes before them is supposed to be dealt with confidentially. However, you should then make exceptions for the commission to be able to disclose it in a manner in which you think fit. And we already have some guidance about that.
From my understanding, SG, the exception would be in relation to government contracts and prescribed licenses generally, as in mention has been made here about the disclosure, the publishing of contracts on a periodic basis. So the exception in the legislation would cover that. That is what you're recommending. Just for clarity.
No, my understanding is different. You believe, SG, there should be a specific section that authorizes the disclosure of those contracts and licenses. Rather than just trying to delete it, amend this section.
Right, I think we're saying the same thing. Yes. Right.
Except I want to go back to the point that Member Charles raised. And I want to ask if when you look at 56(2), Member Charles is concerned that the clause might actually be speaking not to the role of the commission, but to the obligation of the person who works with the commission. Right. And then if you look at 52(2), you see clearly where that duty is also imposed on the person, even if they are no longer there. Now, the way in which the Integrity Commission has interpreted this clause is to say they cannot do certain things, including the publication of government contracts, which they used to do, even after it moved from Contractor General to Integrity Commission. So I am positing that when we are looking at the section and we are looking at the policy, that we indeed need to be clear whether it is a duty imposed on an individual or imposed on the Commission. And the reason why I find Member Charles's intervention attractive is that if you look at 56.1, after it excludes, it protects from disclosure all this information, it goes on to say, except that no disclosure made by the Commission or other concerned person in the proceedings for any offense under this Act or under the Perjury Act by virtue of Section 17.2 of the Act shall be deemed inconsistent with any duty imposed by the subsection. So I think that we need to get some kind of clarity as to exactly what it is we are trying to achieve by 56.1, and bearing in mind that the Commission itself, having analyzed it and assessed it, has come to a particular view that is prohibitive.
So if I may, generally, because any law that establishes a public body, entity, and other laws have confidentiality provisions. The older version used to be called secrecy provisions. We moved to confidentiality. If you look at any of them, they will always put an obligation on the entity, like let's say a board, a commission, but they also put an obligation on each person who works in that entity. It's a dual obligation. However, when you make exceptions to allow the disclosure of documents, that's usually given to, so for instance, in the Serious Fraud Office Act, it's given to the director. So whereas it says, every member of the Serious Fraud Office shall observe the strictest secrecy in basically everything they get, it then says, notwithstanding subsection 1, the director may disclose the information. We have well, maybe it's not quite similar here, but we do have examples in other laws where, I think even in our tax laws, where every member at the TAJ is mandated to keep everything confidentially. But the Commissioner General may disclose certain things. So what I'm saying is usually you will have, it's supposed to be a regime to ensure that when you're going to be doing disclosure, it's done in a regimented way and it's done properly. Having heard also what you have just said as well and looking at the policy, honestly, I don't know that there is a need to highlight government contracts and prescribed licenses in subsection 1, even though they would still be covered, because the general words are still there. And perhaps it does send some sort of message when you highlight those words and have them there. So perhaps the committee, in considering even the policy, may take a decision that you don't need to refer to government contracts and prescribed licenses in subsection 1, but where you are going to put, perhaps still in subsection 3 or some other provision where you allow now for specific disclosures, you could either speak about government licenses, prescribed licenses and government contracts, or you could use wider language. So for instance, you could talk about information that is already available to the public, because some of these contracts would have already been awarded, and these are publicized under the Public Procurement Act. So I'm just saying you have, as well as you can do a mix, you can have wider language, and you can also get more specific when you look at how you want to disclose. My last plug is the committee will need to give very specific recommendations because there is no instructing ministry at these meetings. And so the Parliamentary Council will have to be drafting based on what the committee says and what the record shows.
Thank you, SG. Very helpful. Here are my observations. I think the framework that was implemented in the Act seeks to do a number of things. And I believe that the previous institutional arrangements probably were not sufficiently reviewed to bring the different schemes together under this single regime. And I think that issue has played out on this matter in relation to the powers that were exercisable by the contractor general, what existed there and how they came over. So there is lack of clarity in many of the provisions, and it's therefore not surprising that those who are implementing the law have had so many concerns about it, and in turn have led to concerns by those who are impacted by it. So the review of statutory declarations and the investigations into complaints involve interfacing with very sensitive information that may impact not only reputation but commercial interest. And as a general rule, any information that is being reviewed must be treated sensitively. All right? And the standard that is put is secretly and confidentially. And I think there is good reason for that. But we know that there has to be exceptions, because when you look on what the Commission is empowered to do in respect of the investigation into contracts, conduct of investigation in relation to government contracts and prescribed licenses, it is to investigate registration of contractors, tender procedures relating to government contracts awarded by public bodies, the award or termination of any government contract, implementation of the terms of any government contract, and then in relation to prescribed licenses, the circumstances of the grant, issue, suspension, or revocation of the licenses, so as to ensure that they do not involve any impropriety, irregularity, or breach of any applicable law relating to procurement. And then it sets out exception, Section 52. It's under the part, in order to understand the restrictions and the exceptions, I think it is helpful to understand what the Commission is empowered to do in relation to government contracts and prescribed licenses. So if we accept that what we have empowered them to do, all of those things are legitimate and that the public interest is well served, then the question is, what exceptions should there be and what would be the extent of the exceptions? So there is a clear carve-out of exception in relation to the government contracts that deal with the defense. But again, it's not an absolute restriction. It just requires the prior approval of the Secretary to the Cabinet, acting on the direction of the Cabinet. So the general scheme of the law, and is not to restrict anything absolutely, but to set a threshold before you go into the realm of complete public disclosure, simply because of the sensitivity. And it is why I do not share the view of many others about what has been termed as a gag clause, because it's simply setting a threshold. It's saying before you can go public, send the matter to the Parliament as a commission of the Parliament. But I think the distrust of the Parliament is what causes people to interpret the provision in a way that it was never intended, and on a proper reading of it, you could not reasonably conclude that it prohibits what many says it prohibits. There is just a refusal to accept that the Parliament has authority which is to be respected. And it goes to something deeper in the society. And it is our role to help to educate members of the public that in a parliamentary democracy and a parliamentary cabinet system, the strength of the Parliament must be understood, and parliamentarians themselves have to appreciate it, because the Parliament must operate as a check on executive power when the executive is drawn from the Parliament. But the society believes that there isn't that check for partisan reason, and we have to bring back the strength of the parliamentary system. So the clarity is required, but again, it's because the provisions are so convoluted and they're kind of all over the place, as it were. So we accept, I am suggesting to the committee that we accept as a general principle that matters before the commission and anyone who deals with information, whether by way of review of statutory declarations or investigations into complaints, or treat with the information sensitively and secretly, subject to exceptions. If we can agree, I'm sorry? I'm saying that from a policy perspective, we could agree that any information that is before the Integrity Commission is to be treated sensitively. The standard that the legislation sets is that it must be treated confidentially and secretly. It's a standard that is common to numerous pieces of legislation in numerous jurisdictions. It's not unique to Jamaica. And you'd have seen that from the document provided by the chambers. So if we can agree to that in policy, then it would help the drafter translate the provisions and address the concerns. And then we have the exceptions that are set out in the Act, already set out, and I think those remain good exceptions. I'm sorry? So the real question is, at what stage do you disclose? And what is the extent of the disclosure?
Is it then that we leave in government contracts and prescribed licenses because we're going to create these exceptions? Or we're going to expand the exceptions?
I think the whole provision needs to be reworded. Okay. Madam Drafter. Okay. I think the whole thing will need to be reworded and just simplified. The language has to be simplified. Because the Commission is given certain powers in respect of the conduct of investigations over government contracts and prescribed licenses. I don't think it's the intention to treat everything in relation to government contracts and prescribed licenses secretly and confidentially. That's clearly not, it could not be the intention when you look on the overall scheme of the legislation. Cannot be. Exactly, when you look at what is provided for under that part.
Hence my query, Chair, based on what the S3 read from New Zealand, the exceptions, and we tweak them that are created in that particular statute? Is it that you suggest that we look at wording similar to what is here? For the exceptions?
I am suggesting that first of all, we understand and agree that a duty is properly placed on all persons within the Commission who interface with the information. The matters, the information, whether by way of examination and review of statutory declarations or investigation into complaints, all information is to be treated confidentially and secretly too, right? And then we look on the exceptions. And the exceptions must have regard to a threshold and what is in the public interest. And you make the balance, you strike the balance.
Chair, again, if you read the section fully, and this is not me, I don't have a difficulty, as was said by Member Golding, that if this is being interpreted otherwise, then it perhaps is a basis for a restructuring of the construction of the words. But it is important for us to understand that even in its current form, at least to me, it's clear, that it is trying to avoid unauthorized, premature disclosure, those kind of things. It is trying to protect the integrity of the process. It is not restraining anything because in section 56.3, it says otherwise than for the purpose of this act, which says clearly that if you're acting in accordance with the act, then you can act. It is again, what I would want to move to is to ask members, what would you want to change in this? What construction? What word would you want to remove? Because even if you remove the word government contract, how will it will not impact the ultimate intention, which is that if you are a concerned person, which is defined in the Act, Member Robinson, and you have on your desk information about a company relating to whoever in Jamaica or wherever, you have a duty to keep the thing confidential. You have a duty to keep it secret. But it does not stop the other processes that are going on around, whether it is connected to the act or other acts, from continuing. It's not an effort to restrain in terms of any transparency or accountability. However, all that said, if it is that it is interpreted in a particular way by the Integrity Commission, I have no difficulty with a restructuring. But what I want to know is, what are you going to restructure? What words would you want to remove?
Just a minute, Member Bunting. Colleagues, believe me, we're not passing the laws for ourselves. Laws have to be implemented, laws have to be enforced. The fact that the implementor in chief of the legislation has issues is reason alone for us to just pause and reconsider. It appears from the discussion that as a committee, we agree that it is appropriate to place a duty on everyone who has an official duty under the Act to regard as secret and confidential all information that they're dealing with, all right, as a principle and as a policy. And then there are some exceptions, and the exceptions deal with certain categories of matters. And the exception also relates to a timeline. So you are avoiding premature disclosure and you're avoiding unauthorized disclosure. So the law has to authorize what it is that you can disclose and at what point. So you do not have any premature disclosure or you do not have anything being disclosed that this law itself does not authorize. And what it authorizes for disclosure must obviously be in the public's interest.
Yes, in section 2, where it gives the Director of Investigation powers in relation to government contracts and prescribed license, perhaps there could be a section in a separate section that gives the Director of Information and Compliance the power to just publish the existence of these government contracts and prescribed licenses, specifically the registration of contractors, the tender procedures, the award of contracts.
The member is referring to section
No,
52.
I'm referring to section 52.
Yes.
I'm saying, whereas this 52 is giving powers to the Director of Investigation, I'm saying there could be a similar section that gives powers to the Director of Information just to disclose this similar information in the sense of the existence of the government contracts or prescribed licenses, the registration of contractors, those contractors who are registered, the tender procedures, the award or termination of any government contract or prescribed license, and so on. So I'm saying this here refers specifically to an investigation, but I think just for information, the Director of Information could publish, there could be a section authorizing him to publish the existence of these government contracts and prescribed licenses once they're awarded, and to include the registration of contractors and so on, which was exactly what used to happen under the old Contractor General's Act.
Point taken, Member Bunting. Is there an error in the chapeau of 52.1? Is a word missing? That it shall or may? Or is it that I'm not seeing it? Please read section 52.1. Ah, I see. No, right. That's what I wasn't seeing. Okay. All right. Just a minute, Member Chuck. Just a minute. Member Bunting is proposing that specific provision be included to allow for the publication of the registration of contractors, the tender procedure relating to government contracts, the award or termination of government contracts, and the implementation of the terms of any government contracts, since there is power to investigate those matters. So before, I'm sorry? Yes, right. So we're coming to that. I was coming to that, right.
Let me say, Member Bunting, we have to be very careful how you cause the Director of Information to be publishing all these things. First of all, it's a burden. There could be hundreds of contracts being awarded every month. And to say that the Director of Information must publish them, my understanding is that government contracts are public knowledge. So to the extent that a ministry has given out 5, 10 contracts, they don't have to, but I believe that all ministries should publish contracts maybe over a certain amount. But once you say that the Director of Information must publish them, it might leave the impression that having published them, he's investigating them. No, I'm just, why would we want the Integrity Commission to be publishing?
Member Chuck, in the interest of time, may I just make a suggestion?
Yes.
If we agree that the public interest is served by the publication of the contractors who are registered, the award of contracts, and the procedure, if we agree on that,
yes,
then the question is
who,
hold on,
right.
the question is, should they be published? And I think the answer to that is a simple yes. So the other question is by whom? I do not think that it answers the concern that they are public knowledge. When people want to have access, they want to know that they can go to a central point to provide for it. Now, before the House, we have some amendments to the Public Procurement Act.
Right.
And I believe there is an entity. I'm sorry? And it is already in the Act.
Exactly.
It is already there.
So
So
the
what we are
procurement-
also finding,
If you'd allow me. So, yes, the Public Procurement Act does provide in section 45 for public notice of awards of contracts. And it tells you you must publish a notice of the award, and there's a format
Who is supposed to
including
do
the
it?
name,
Who is supposed to do it?
the procuring entity. So it will be the MDA. Well, yes. But so I just wanted for the record, though, just to say that there is already an obligation on each procuring entity to publish notices of awards of contract, to include the name of the contractor, and in the case of a procurement contract, the contract price. However, from what I'm understanding from Member Bunting, he's now looking at the very specific duty given to the Director of Investigation in Section 52, which outlines a number of things that can be investigated. And he has then posited that there should then be a power for the release of that information. Or publication of that information. Okay, publication of the...
Not of the publication of the investigation, the fact that they're being investigated. I'm just saying the fact of the existence of these contracts and prescribed licenses.
But why?
Now, there may be an obligation under this new procurement bill for the act, that every MDA, ministry, department, or agency, who the procuring entity is, publish it. But we're talking about hundreds of entities across the government sector. What the contractor general used to do, and I believe there was a threshold. I don't think it was every time you bought a pack of paper clips, but there was a threshold at contracts above that threshold. They were reported to the office of the contractor general, who then published them quarterly. And all I'm saying is a corresponding power could be given to the Director of Information, not investigation, the Director of Information. This is in the interest of transparency to the public and ease of the public finding this, to publish that information similarly to how the contractor general did it before, the office of the contractor.
I'm going to now go further than to say, yes, so quarterly reports are submitted by every MDA to the Integrity Commission indicating whether contracts were awarded and the spend. And so the issue is, how could that, just that kind of basic information, how could that be disclosed? I don't see a legal issue with disclosing it. I, however, don't agree that it should be done by the Director of Information, because I think you may end up having an issue with one director having a power to do something, another director having another power, and I think they may have an issue in terms of how they interpret those provisions. I would suggest that it should be the Commission that is given that power and not the Director of Information. And I think also that could be dealt with in that same provision you're looking at in 56 that talks about what can be disclosed. Because I thought what the committee wanted was a provision that outlines the different things that can be disclosed without it being an offense. So I would suggest that perhaps that would be one of the things you could itemize as a specific exception to the confidentiality provision.
Chairman, what Member Bunting is asking for exists at the moment. Each entity provides the Integrity Commission with information on all contracts that go through them. All the contracts go through and reported to the Integrity Commission. And where the PPC is concerned, every contract or tender above 30 million at this stage has to go through the Public Procurement Commission.
All right, so here, let me see if I am...
No, just one second. Member Wilmington has said exactly the position. I agree totally, Chairman. All contracts above a certain limit, above 10 million, 20, whatever the figure is, Member Wilmington said 30 million. It may well be 20. We want to reduce it to 20 or increase it to 50. But all contracts should be made public. Who is going to make it public? I don't think it should be the Director of Information, as Member Bunton is suggesting. I think the Integrity Commission should make sure that all contracts from every government department is published on their website or some, so that the public is aware. But I don't think you should impose it, as SG is saying, on the Director of Information. It should be... No, right. So the Commission, as a body, could ensure, working with the procurement, as Member Wilmington said, that everything is published.
All right. It appears to me, in considering all of the issues, that the committee agrees that all matters that are dealt with by the Commission and anyone working with the Commission is to be treated confidentially, secret and confidentially. And then we have to clarify the exceptions. And so the duty to treat as secret and confidential matters, breach of that duty would be an offense as is currently expressed in the law. That there would be exceptions to that, and the exceptions would prevent premature disclosure and unauthorized disclosure. And we would set out, we would clarify what the Commission can disclose without it being an offense, the Commission and anyone working within, as an exception to the confidentiality and secrecy provision. Let me do a take two on that. It appears that the committee is making a recommendation that the provisions of the Act be rationalized and clarified to make it clear what can be disclosed without it being an offense. To the duty to treat confidentially and secretly all information being dealt with. And then, secondly, that all awards of contract reported to the Integrity Commission should be published by the Commission itself, not any of the directors. And then that would allow the public and the Commission to track the matters that are set out, matters that may come under investigation at Section 52(1) of the law. So we're clarifying the power of the Commission to disclose information without it being an offense. This would be as an exception to the secret and confidential provision. And then we're going to guard against premature and unauthorized disclosure and allow for the publication of all awards of contract reported to the Integrity Commission. Yes, by the Commission. So what they're saying is that no, there is some doubt as to whether they can publish it. But already matters are reported, but they are not published, and they used to be published under the Contractor General provision. So it just requires some clarity around that. Yes, members? All right, so that's the decision. We can translate it. I think that is as far as we can go today. We would have made good progress. All right? So we are retaining the duty to treat as confidential and secret all information that goes before the Commission or any person employed in the Commission in the exercise of its duties. We have exceptions. We're going to guard against premature and unauthorized disclosure. And to bring it together and to avoid any doubt, the all awards of contract reported to the Integrity Commission is to be published by the Commission, not a director, but by the Commission. All right? Yes? Though, yes, because that is how it used to be, and they now believe that they can't do so by virtue of 56. So that would clarify that issue, and I think it would achieve the goal that they're seeking to have us achieve by striking the right balance. All right, I believe we can report progress from today's meeting. So we'll see how the matters are captured for confirmation. I'm sorry? No, I don't believe so. I think the concern... Right. Right. Well, we can haggle over that. Let's... They should be empowered to publish the awards of the contract. That's it. Whether to make it mandatory is another matter, but we're empowering them to publish the contracts, the awards of contracts reported to them under the relevant law. All right. So date and time. Is there any other matter? Any other business? Yes.
Mention was made about the Inspector General in Australia, as it relates the Inspector General for the Integrity Commission. I don't know whether asked the Solicitor General for a whole lot of information. I'm wondering if it's possible to, if they could get from them at the next meeting or sometime, some information as to how it operates.
How?
The Inspector General for the Contractor General's office.
Oh.
In Australia has an Inspector General for the Integrity Commission. So I wonder if they could assist us as to, how it works.
All right, so the request is the committee making a recommendation for advice from the Solicitor General, the Attorney General's chambers, on how the Inspectorate General for the Office of the Contractor General operates in New Zealand? Australia? Australia, very well. All right, so the chambers will advise. All right, Member Goldin.
I was just suggesting, Madam Chair, that request might be better executed by legal reform.
All right,
I understand what Member
If
Warmington
that's the only
is asking.
issue, then the recommendation is that the committee be assisted with some information from the Legal Reform Department on how the Inspector General for the Integrity Commission operates in Australia. Date and time of the next meeting, if there is no other business. The date and time to be fixed, it's now 12:29. We take the adjournment on the motion of Member Warmington, seconded by Member Hamilton.
shatters. The 14, the 15, the 16-year-olds. You still have time to change your future and enjoy your life. No lock, no gun for no guy. And no bother hang with no crowd that is all